Also, Passover case contains 669 of 2023 from first division.
Sorry?
For the 1 week of time they gave regarding the current position of this.
Regarding the
Current position of this.
have you filed or you have not filed?
Lord, I have to see instruction regarding
कल बताइए. You made a submission that you have already filed. You are going to file it. You have made a submission that you are going to file it on 29/8.
Check the SIP has not been filed. It is not showing on the website.
पता करके बताइए. अभी पता करके बताइए. Right? आज ये 4 बजे. 4 o'clock. I want a positive statement, clear statement that it has been filed or it has not been filed. और LPA का order कब का है?
4/7/2025 for dismissal.
4/7/23 का order.
25 dismissal.
4/7/23. अभी टाइम है, लिमिटेशन नहीं है इसका. ये कंटेंट में लिखिए तो. At the request of the counsel for the opposite party, was this case on 14th November.
Under heading for hearing under order 41 rule 11 of PPC item 33, second appeal 538 of 2016.
Lordship, they have not informed us, Lordship. Even on the last occasion also, he had just only by sending this mention slip, Lordship, adjournment was taken. And prior to that, Lordship, 10,000 rupees cost was imposed upon him. Intentionally, he is avoiding the court.
There is an objection in connection with the name in the Wakalatnama filed on behalf of 2, 3, 5 to 8, 11, 16, 17 and 19. That is to be rectified. It's important. ये तो करना पड़ेगा ना. Verify कर लीजिए. वैसे it's not proper बिना information के. Essay number 538 of 2016, and a genuine slip has been circulated by the counsel for the appellant. The counsel for the respondents has submitted that he has not been intimated
Even on the last occasion also, Lordship, on 79.
about such prayer. He has also submitted that on the last occasion when the case was taken up on 17/9/2025, the appellant was absent and a request for adjournment was circulated by the counsel for the appellant. But on that day also, no advance notice for adjournment was given to the counsel for the consent from the other side.
Lordship, they have not even
The-
talked,
The adjournment notice which has been placed on record today mentions that Consent from the other side has been taken. Last time का भी तो होगा ऐसा. इसलिए हटा देते हैं आपको. इसलिए हटाते तो नहीं होंगे. मिसप्लेस नहीं करने का ना इसमें. This aspect of the matter, since the council is absent today, this aspect of the matter will be taken care of on the next day. खाली याद दिलाइएगा इसे. हटाइएगा मत इसे. ये फोटोकॉपी क्यों लगा? मेल से आया. However, from the records of this case, it appears that certain objection has been raised by the office regarding wakalatnama filed on behalf of respondent number 1A, 1B, 15A and 15B, and also in connection with respondent number 2, 3, 5 to 8, 11, 16, 17 and 19. The learned counsel for the applicant submits that he shall go through the records and do the needful. आपको फ्रेश वकालतनामा फाइल करना है.
कर देंगे.
वकालतनामा में कोई भी छेड़छाड़ नहीं करना है. You never know how the litigant behaves. Considering the submissions of the learned counsel for the respondents, this court is of the view that no advance request of adjournment will be entertained by the counsel for the applicant in this case for the next date. Stop order, don't accept it. इसको याद रखिए. Let a soft copy of this order be forwarded to the learned counsel for the applicant, Mr. Bahia Kishuri. नेक्स्ट डेट कब का रखते हैं बताइए.
Any date.
आपको फ्रेश वकालतनामा
Lord,
थोड़ा
sit
चेक कर लीजिए.
I will file it on 6 Lord. So
नहीं नहीं, आप थोड़ा चेक कर लीजिए ना क्या ऑब्जेक्शन है क्या.
तुरंत verify.
कब रखते हैं? 7
Lord.
पोस्ट ऑन 7.
Bas.
Item 34, 2nd April 291 of 2017.
The plaintiff's suit was dismissed. Thereafter, he has preferred an appeal, and that was also dismissed. Thereafter, he is in second appeal, the judgment of concurrence. The suit was for declaration that the sale deed dated 2nd of September 1998, executed by the defendant number 2 in favor of defendant number 1, is void, illegal, inoperative and without consideration, and does not affect the title of the plaintiff, and also for permanent injunctions. Ad honorem court fee had been paid. The suit was instituted on the ground that defendant number 2, who is the father of the plaintiff, has executed the impugned sale deed of 2/9/1998, even though the property was a joint family property acquired on the joint family fund, And second ground was that he was not of complete sane mind.
In the name of defendant number 2.
The property was purchased in the name of defendant number 2. He said it was from the joint family fund, so it was a joint property as such. However, ladyship, the findings by both the
Father,
courts.
this is one ground. Second
First ground is that it was our joint family property, acquired out of joint family funds. Second ground was that the father was not sane. So the defendant number 1, in collusion with his husband and other relative, was able to.
His husband means? Whose husband?
Defendant number 1 husband. Who's the purchaser? From defendant number 2.
In collusion with defendant number 2.
In collusion with taking aid of defendant number 1 of a husband and the other relative of the defendant number 1 herself, has been able to got the sale deed executed. Impute sale deed.
Her husband is also a party.
No, husband is not a party. Defendant number 1 husband is not a party. Ladyship, the finding which has come is that the plaintiff has not been able to prove that there was a joint family fund or the property was acquired on a joint family nucleus, having sufficient nucleus to actually purchase that property. However, that Lordships, one finding has been recorded by the learned lower appellate court that since there is a challenge to a sale deed, there ought to have been declaration of title. That finding, if your Lordship sees the relief portion of the plaint which has been quoted at page 4 of the lower appellate court judgment, it will be clear that he has actually sought a declaration of title also, because he says that it was not affected. His title is not affected by the impugned sale deed. So that title has been asserted and ad honorem potentially has also been paid.
That doesn't cut much ice. There's nothing in this. This defendant number 2 was a school teacher.
Yes, he was a school teacher.
He told me that he was unconscious. Your father take care of him. Essay number 291 of 2017. For the learned counsel appealing on behalf of the appellant. This appeal has been filed against the judgment dated 25/3/2017 within bracket decree signed on 6/4/2017 bracket close passed by learned District Judge Roman Court Dhanbad entitled appeal number 120 of 2007, whereby the learned court has dismissed the appeal and affirmed the judgment dated 15/6/2007 within bracket decree dated 28/6/2007 bracket close passed by learned Sub-Judge Roman C. Dhanbad in title suit number 15 of 2002. The trial court had dismissed the suit.
Trial court issues are at page para 7.
The suit was filed that consequently the plaintiff is the appellant also.
Yes.
The suit was filed for a declaration that the sale deed dated 2/9/1998, bearing number 5624, is void, illegal, inoperative, and without consideration. And the defendant number 1 has not acquired any right over the suit property through this sale deed. As such, the same be declared cancelled and set aside. A prayer was also made seeking permanent injunction restraining the defendant number 1 and his servants and agents from interfering with the possession of the plaintiff over the suit land, cost of the suit and other relief. The learned counsel for the appellant submits that though the plaintiff has lost before both the courts, but substantial question of law arises in the present case inasmuch as the learned courts have not appreciated the evidences placed on record properly. The learned counsel has submitted that the learned first appellate court
At internal page 11,
at internal page 11
at bottom.
has recorded that the exhibit A, that is the say deed,
Seal.
impute say deed, cannot be said to be void or voidable as the same is a registered document and a suit for cancellation of document is not maintainable unless the plaintiff had filed a suit for declaration of his or her title and consequential relief. The learned counsel, the court has also held that the suit filed by the plaintiff for declaration of title, the suit has not been filed by the plaintiff for declaration of title, rather it has been filed for declaration of the say deed as void, illegal, inoperative and without consideration, and the document be cancelled and set aside. The learned counsel has submitted that if the prayer of the plaintiff in the suit as quoted in paragraph 1 of the trial court's judgment is taken into consideration, in effect, the plaintiff had also sought declaration of his title. And therefore, the finding of the learned first appellate court is incorrect. Further, he has submitted that the courts have held that the plaintiff has not been able to prove the nucleus of the joint family, and the plea that the father of the plaintiff, that is defendant number 2, was of unsound mind has been rejected.
We have led evidence to, but oral evidence only, as no documentary proof. That that the joint family fund was there. Only on the basis of
The
oral
learned
documentary
counsel has
evidence.
submitted that though no documentary evidence was produced, but oral evidences
Yes.
were produced to
Yes.
show that there was a nucleus
Yes.
of joint family. But this aspect of the matter has not been properly considered. After hearing the learned counsel for the appellant, this court finds that the relief as
That is quoted in the trial court decree.
yes,
and
as
the-
prayed for by the plaintiff in the suit is quoted in the as per the decree is as follows. Especially on the perusal of the relief, No prayer has been made for declaration of title of the plaintiff. So far as the merit of the case is concerned, it was the specific case of the plaintiff that defendant number 2, his father, and he himself constituted a joint family governed by Dakshara School of Hindu law, and defendant number 2 and they were and defendant number 2 had sufficient ancestral land at Aurangabad, and he acquired land for valuable consideration by registered sale deed number 8156 dated 9/8/1980, and the consideration was paid from the joint family fund as well as from the assets of the plaintiff and the defendant number 2. But the sale deed was taken in the name of defendant number 2, who is the eldest brother and karta of the family. Thereafter, the plaintiff and the defendant number 2 constructed rooms and compound over the property way back in 1985. All from the joint family income and ancestral agricultural fund land and income from agricultural land in which the plaintiff had also contributed, as he is an agent of LIC, as well as engaged in driving private car. It was further case that the plaintiff, it was further case of the plaintiff that the defendant number 2 was of unsound mind, and he came under the influence of the husband of defendant number 1, and in collusion with each other, they got the deed executed in their favor by defendant number 2. And the deed was collusive, fraudulent, and consideration amount was never paid to defendant number 2. And the possession of the property was also granted. The plaintiff claimed that the cause of action arose on 3/2/2000 when the plaintiff and the defendant number when the defendant number 1 and her husband for the first time came to the plaintiff and asked the plaintiff to vacate the building on the basis of registered sale deed executed by defendant number 2 in their favor, which is the impute sale deed in the suit. The written statement was filed opposing the prayer, and it was asserted by the plaintiff, defendant number 2, that the property was acquired out of his personal and individual income from his service, as defendant number 2 was a teacher employed in government school. And the defendant number 2 asserted that it was the self-acquired property of defendant number 2. The other plea of unsound mind was also denied. The learned trial court recasted the issues in paragraph 7 as follows. Para 7 से trial court के judgment से. The learned trial court considered the issue number 5 and after perusing the materials on record, both oral and documentary, came to a clear finding that the suit land was never purchased and acquired by defendant number 2 in his name out of joint family fund property, but the same was acquired by his independent income. Paragraph number 22. So far as issue number 4 is concerned, the learned trial court, after considering the materials, has recorded a finding that the plaintiff could not prove that by playing fraud upon the defendant number 2 by the husband of defendant number 1, the defendant number 1 acquired right title and interest in the suit land. Para 35. Para 35 नहीं, para 43. Para 35 and para 43 ये दोनों कोड छोटा छोटा. The learned first accurate court framed the point for determination in paragraph 12, which are as follows, and decided all the issues against the plaintiff by considering the documents, materials on record. This court finds that the learned court has arrived at concurring findings that the property acquired by defendant number 2 versus self-acquired property and was not purchased from joint family property, and no fraud was played by defendant number 1 or her husband for executing the sale deed by defendant number 2. There being no substantial question of law involved in this case, the settlement is hereby dismissed.
Item 35, second appeal 122 of 2022.
May please your attention. Lordship, this is plaintiff's second appeal against the judgment of reversal. Lordship, partition suit number 65 of 89 was filed, praying therein, Milord, for declaring plaintiff's half share in the suit property, and also for declaration, Milord, that the sale deed dated 23/7/1988 executed by the defendant number 1 in favor of defendant number 2 is void. Now, Lordship may kindly see the plaintiffs and the original defendant. Plaintiff number 1, plaintiff number 2, and the original defendant, Milord, Sachindra Prasad Singh. They jointly acquired, Milord, the suit property by virtue of registered sale deed dated 24/11/1977.
Just
Lordship.
who are plaintiff and
Plaintiffs and the original defendant, Sachindra Prasad Singh, who died, Milord, during the pendency of the suit, and his heirs have been substituted.
jointly purchased.
Jointly purchased, and Milord, sale deed has been exhibited.
Sale deed number
Lordship, sale deed number 2355
Dated,
dated 23/7/1988.
exhibit number.
Exhibit number 1.
This is the sale deed under challenge. This is the sale deed under challenge.
23/7/1988. This
This
is
is the impugned
under
sale deed.
MEP impugned sale deed.
Who challenged it?
The
Why did plaintiff challenge it?
Plaintiffs, my lord, because the property was purchased jointly by the plaintiffs and the original defendant. Therefore, my lord, the plaintiffs have half share in the suit property.
Okay.
The plaintiffs claimed half share. In the meantime, the original defendant, has already sold the suit property, my lord, to the defendant number 2. Entire suit property. The trial court came to a specific finding that the plaintiffs are legally entitled to get half share in the property, and the sale deed executed by the defendant number 1 in favor of defendant number 2 is void.
Void only to the extent of half share or completely void?
Completely void.
While defendant number 2 also had title over the property.
Title, but my lord, I am entitled to get half share.
Yes. you are-
Entire property has been transferred
That's right.
without taking my
That's
consent.
right, your consent has not been taken.
Lordship.
But at the same time, he had title extent to the
He,
extent of
they
half
are
share.
half share, my lord, they are entitled. I am not disputing. Now, lordship, the first appellate court has held that the sister of the plaintiff has not been made party. Therefore, suit is bad on account of non-joiner of necessary party. Although this issue was not pressed, lordship may kindly see the trial court judgment. And the learned first appellate court has reversed the finding of the trial court on the ground that the suit filed by the plaintiff is bad on account of non-joiner of necessary party.
This plaintiff and the original defendant, are they otherwise family members?
Family members,
Plaintiff and the original defendant,
original defendant,
they are family members.
lordship,
They are seeking partition.
lordship,
The plaintiff was seeking partition.
partition, half share, my lord.
Then it could be a ancestral property also, derived from ancestral property.
No, lordship,
In
this
a partition suit,
partition suit, lordship, the sale deed stands in the name of the plaintiff number 1 and 2 and the original defendant. I am claiming half share. This is the case.
suppose.
Sister of the plaintiff is not a necessary party, lordship.
In a case where the co-owners of the property as per the registered deed are of the same family, then there could be a case of one or the other person that the property has been acquired from joint family.
But this is altogether a different case. This is altogether a different
Unless
case.
the sister is there on board, who will say that it has been acquired from a joint family?
Because, my lord, the property stands in the name of the plaintiff number 1 and 2 and the defendant. Therefore, my lord, they are presumed to be the owner of the property. Now, lordship may kindly see the findings of
Let us
the
see the case of the plaintiff.
lordship.
What was the case of the plaintiff?
The case of the plaintiff is, my lord, that the plaintiff number 1 and 2 and the original defendant Sachinder
You
Prasad.
read it from the judgment.
Lordship,
Yes, para number 2
2.
on the trial court judgment.
Lordship. Plaintiffs have brought the suit in hand for decree, declaring that the registered sale deed dated 23/7/88 executed by the defendant number 1 in favor of defendant.
ठीक है, para 2 से पढ़िए.
G. The case of the plaintiff as it appears from the plaint in short is that parties are Hindu and governed by Mitrakshara school of Hindu law, and the plaintiffs are the nephew of the defendant. According to these plaintiffs, the suit property was originally part of the old holding number 218, ward number 14 of town plan number 21, and thereafter now become holding number 237, ward number 14 of Moja Shyamganj, Caster town, originally belonged to Sri Kalyan Kumar Dev and others, from whom the plaintiffs and defendants acquired the same by purchase for valuable consideration by registered sale deed number 2997 dated 11/11/1977, registered at Devghar Registry Office. It is further submitted that parties were member of co-partnership and the suit property is their separate property, and after purchase parties' names were mutated in the register of municipality and circle office, and these documents have been exhibited. Plaintiffs and defendants have half and half share in the suit property. Part of the suit property consisting of shop, a stall let out to the tenant on payment of rent. Parties along with other co-sharer have also got agricultural land and other property in Moja Nagara, Kolihari, Gangapur, Harlada and other villages which are under settlement notification number such and such. But the suit property is being situated in the municipal town of Devghar, so within the jurisdiction of this court. There are other co-sharer and also ruler of the property which are being possessed according to the temporary arrangement in anticipation of final partition. It is asserted that in view of the separate character of the suit property and keeping in view large number of co-sharers in the rural property situated in different villages, all are not included in the suit. In view of the separate character and jointness between the parties of the suit, it is further asserted that after death of the plaintiff's grandfather, the defendants being eldest male member became karta of the family, but he has developed dishonest intention as a result of which difference has cropped and widening between the parties. So plaintiffs requested and demanded amicable partition of the suit property, that is half share, but the defendants went on deferring the matter for some time on another pretext like marriage of daughter, etc. Ultimately, they refused to partition in October 1989. Hence, this necessitated for filing the suit. It is further asserted that self-acquired property of the plaintiff and defendant number 1, and the latter has no right to alienate the plaintiff's half undivided interest in the same. It is further asserted that on refusal by the defendant number 1 to give necessary particulars and after obtaining certified copy of registered sale deed number 2355 dated 23/7/1988 on 4/5/1991, the plaintiff came to know that in order to harass the plaintiff, the defendant number 1 has illegally and dishonestly executed the said illegal, malafide and void sale deed in favor of the defendant number 2 regarding the suit premises consisting mainly of the joint dwelling house, and had himself assumed the status of monthly tenant under the purchaser in regard to the said dwelling house of the plaintiff. In view of the above development, are entitled for adjudication that said illegal sale deed with false recital is not binding on plaintiffs. It is further contended that plaintiffs are further entitled to buy off defendant number 2 by paying half of the consideration money, rupees 23,900, and obtain possession of the entire suit premises after evicting defendant number 1 on account of non-payment of rent. Plaintiffs are also entitled to get the rent. It is further submitted that the plaintiffs are also entitled to shed relief under the equities of partition under the Partition Act and also under section 44 of the Transfer of Property Act. It is further stated that defendant number 1 is not a karta of joint family. According to these, plaintiff cause of action of the present suit arose on 3rd week of October last, and thereafter Miller's suit was filed. Now, Lordship may kindly see the case of the defendant.
Just a moment. The defendant number 1
Lordship.
and the grandmother of the plaintiff had also joined as a co-executant of the deed.
No. Lordship, deed was executed.
Page 9. The mother of the defendant number 1 and grandmother of the plaintiff also joined as co-executant in the
In the Kevala executed by defendant number 1.
Yes.
But my lord, the earlier said deed by which the plaintiffs, my lord, the plaintiff number 1 and 2 and the defendant, they have purchased the suit.
They have purchased the suit, but why will they enter as co-executant of the deed?
Lordship, this is the case of the defendant number 1.
Maybe, but if once this fact comes into light, then under such circumstances, the ladies of the family becomes necessary party.
Lordship, sale deed will be taken into consideration if sale deed stands, my lord, in the name of the plaintiffs and the defendant. Then, my lord, the plaintiffs are certainly entitled to get half share in the property. Lordship, may kindly see the provision on.
Joint family, when a person is a karta, then under such circumstances.
No, that has been denied and it is well proved. Lordship, may kindly see. So far as necessary party is concerned, a specific issue has been framed and it has been dealt with by the learned trial court. Lordship, may kindly see for a moment.
But the plea was already there. The genealogy is already there. The
But-
plea of
but-
non-joinder of party is already there.
But no evidence was that pleadings, Lordship, pleadings are required.
It is an admitted fact that those ladies are members of your family.
Lordship, may kindly see.
Which is there?
Just for a moment. Issue number 3 has been decided by the learned trial court, my lord. Page 29, Lordship, may kindly see. Para 22. Nothing has been brought on record by the parties, that is particularly by the defendant, to show that the suit is defective of necessary party. No evidence has been adduced by the parties to suggest this court that the suit is defective of the necessary party. This issue has not much more agitated during.
Page number 12 में आएगी.
हाँ.
PW1 का एविडेंस पर. Bottom में 5 लाइन. According to this witness,
The consideration amount of the suit property was paid by the mother Shiv Kumari Devi after selling her jewelry, and it was decided that the property of Devghar be purchased in favor of the plaintiff and defendant's first party. So, property of Devghar was separately purchased between plaintiffs and defendant first party. अगर sale deed नहीं होता, the matter would have been otherwise. But sale deed stands in the name of.
no, merely because the sale deed is standing in the name of the karta of the family, that does not mean that it is a self-acquired property.
Lordship, may kindly see the provision contained in section 3 of the Benami transaction. Property, my lord, stands in the name of plaintiffs and defendant, will be treated as self-acquired property of the plaintiffs and the defendant. And the.
You see, do you want to say that the property, if the property is acquired from the joint family fund in the name of one or the other brother, then it ceases to be a joint family property by virtue of Benami Transaction Act?
Cannot be.
Then
Cannot be. But this is altogether a different case. The defendant, my lord, has failed to prove, Lordship, may kindly see, that he was the karta, and being karta of the family, he acquired the property in the name of the plaintiffs. There is no evidence to suggest. Rather, my lord, sale deed has been exhibited, which would go to prove that the property was purchased in the name of the plaintiffs and the original defendant. And as such, my lord, the plaintiffs are entitled to get half share in the suit property. Moreover, entire land has been sold, my lord, by the defendant number 1 in favor of defendant number 2. And the learned first appellate court, my lord, lordship may kindly see, has not met, my lord, the reasonings of the learned trial court while upsetting the judgment, lordship, on absolutely irrelevant consideration of the materials on record.
It has come in the
Now, lordship may kindly see the findings of the learned first appellate court. The learned first appellate court has also held that this court convincingly holds that the suit property is the joint family of the party plaintiffs and defendant number 1. And lordship, page 13. Lordship may kindly see. Therefore, from the aforesaid admission and indication about the purchase and usage of the suit property, it is very much clear that this court convincingly holds that the suit property is the joint family property of the parties, that is plaintiffs and defendant number 1. Even that reverse define now lordship may kindly see page 16 of the learned first appellate court judgment. Page 16, just for a moment, lordship. Fifth line from the bottom, lordship.
Just a
In the present case,
moment. Just a moment.
lordship. Lordship may kindly see page 16. Fifth line from the bottom. In the present case, it has been held so far as yet that the suit property is the joint family property of the plaintiffs and defendant number 1, appellants, and there was no legal necessity being proved by the defendants to sell the suit property. Even then, my lord, it has been reversed.
That's all. Case of being substantial.
Lordship
And,
may-
and you see, you're right? It's not foreclosed. The reason is that you can still join the sisters and file a question. There is no bar.
Lordship, after all, my lord, sister is neither a necessary nor proper party, my lord,
Sister is a
for real adjudication of the list. Lordship may kindly see. This is the finding of the first appellate court. First appellate court also came to a finding, my lord, that the property belongs to the plaintiffs and the defendant number 1.
And joint family property.
Joint family property of the plaintiffs and the defendant number 1. And the plaintiffs are claiming half share in the suit property.
That's
And my lord, lordship may kindly see the provision contained in order 1 rule 9 CPC. No evidence has been laid, my lord, by the defendant, which has been recorded by the learned trial court, my lord, while decreeing the suit filed by the plaintiff, and that has been reversed in appeal. Lordship may kindly hear it, my lord. Substantial question of law is involved, Lordship.
For claiming substantial question. For the learned counsel appearing on behalf of the applicant. This appeal has been filed. The Benami Transaction Act has been filed against the judgment dated 3/8/2022 with a bracket decree signed on 11/8/2022, passed by the District Judge Roman 2 Devkar, whereby title appeal number 19 of 2018 has been allowed, and the trial court's judgment dated 28/2/2018 with a bracket decree signed on 9/3/2018 by the civil judge with a bracket senior division bracket close 1 Devkar, entitled with a bracket partition bracket close suit number 65 of 1989. The suit was decreed by the learned trial court. And the learned first appellate court decreed by the learned trial court by holding that and the learned trial court reversed the decree. The plaintiff is the appellant before this court. The counsel for the appellant has submitted that the property was purchased by the plaintiff and the original defendant, namely Sachidanand Jha. क्या नाम था उसका?
Sachindra Prasad Singh.
Sachindra Prasad Singh,
Lordship.
who belong to the same family,
Same family.
jointly by SAD number 2355 dated 23/7/1988 within bracket exhibit 1. And the
No,
suit was filed,
dated Lordship 24/11/1977.
sorry, dated 24/11/1977, exhibit 1 मिल जाएगा. And it was a case of the plaintiff that the same was personal property, separate property. However, the defendant number 1 transferred the entire suit property by registered sale deed number 2355 dated 23/7/1988 in favor of defendant number 2. And therefore, the suit was filed for declaring that the registered sale deed number 2355 dated 23/7/1988 executed by defendant number 1 in favor of defendant number 2 is void, illegal, inoperative and not binding upon the plaintiffs, and they are entitled to buy off the defendant number 2 on payment of half price amounting to rupees 23,900 and were also entitled to obtain possession of the suit property after evicting the defendant number 1 a prayer was also made for a preliminary decree declaring that the plaintiffs have half share in the suit property and for appointment of legal commissioner for partition of the suit property by means and bound and for allotment of plaintiff's share and cost. The learned counsel has submitted that since the property was in the joint name of the plaintiff and defendant number 1, it was their separate property and therefore there was no occasion to impede the daughters of the family in this. He submits that before the learned trial court, though issue was framed regarding non-joinder of necessary parties, but the learned trial court recorded that nothing was brought on record by the parties, particularly the defendant, to show that the suit was defective for necessary party. And no such evidence was adduced. And this issue was not much agitated by the defendants during trial, and consequently, the issue was decided against the defendants. The learned counsel submits that the learned first appellate court has reversed the decree primarily on the ground that the suit was bad for non-joinder of necessary parties. The learned counsel has referred to the provision of Benami Property Transaction Act 1988 and has submitted that the property standing in name of 2 persons are for all purposes to be treated as their own property, and such property could not have been treated as joint family property. He submits that the entire approach of the first appellate court, by setting aside the judgment of the learned trial court, is not in accordance with law. He submits that a substantial question of law be framed and decided by this court. That is all. After hearing the learned counsel for the appellant, this court finds that it is not in dispute that a registered sale deed dated 2997 registered sale deed number 2997 dated 11/11/1977 was purchased by plaintiffs and defendants jointly, and they are Agnetsen
Lordship.
They are the members of the same Hindu family. However, the cause of action arose when the suit property was sold by the defendant number 1, who was the owner of the suit property as per the CD dated 11/11/1977 in favor of defendant number 2, while CD number 2355 dated 23/7/1988. And ultimately the suit was filed for the relief as mentioned above. Thus, the suit was filed for not only setting aside the aforesaid registered sale date dated 23/7/1988, executed by defendant number 1 in favor of defendant number 2, but also the suit was filed seeking partition of the property by means and bound. The specific case of the plaintiffs was that they are Hindus governed by Mitakshara school of Hindu law, and the plaintiffs are the nephews of the defendants. It was their further case that though they were members of Upasnali, but the suit property was their separate property, which was purchased by the plaintiffs and the defendants by registered sale deed number 2997 dated 11/11/1977. Defendants क्यों लिखा है?
Though there are two dependents, Lordship. Dependent number 1 has sold the property to dependent number 2.
तो purchase 77 से में किसका नाम था? Defendant number 1.
1.
And consequently, the plaintiff claimed half share of the property. The defendant, it was further asserted in the plaint itself that defendant number 1 was not the karta of the joint family. So far as the written statement is concerned, the defendant first party gave a genealogy as recorded in the trial court's judgment and raised a plea of non-joinder of necessary parties. It was asserted that the defendant that father of the